I hold in front of me, and in these hands, two delicious-looking cookies brought in by our next guest, Berkeley County Prosecuting Attorney, soon-to-be Judge, Catie Wilkes Deligatti. Good morning.
Before we go, this is the last time we can call her Catie. From now on, it's got to be Judge. So let's take full advantage. Let's use Catie every other breath.
Now, you and John also got cookies, Bill.
We did, yeah, but you got two. We only got one.
I want you to know.
What's wrong, Catie?
That you have to split yours with Gilstrap. I'll split mine with Dylan. How's that? Does that work, everybody?
That works.
All right, we're all even up now. Catie, good morning to you.
Good morning.
Or if you prefer, Judge-elect.
I'm good with Catie. We'll roll with that.
Good with Catie. Bill was pointing out during our commercial break that you're leaving office on quite a roll here.
Oh, thanks. Yes, it's been a busier than I expected December. And let me steal that thread for just a second and say, everyone's aware that it's pretty snowy outside. The schools canceled today in Berkeley County. Everyone says the best thing to do as a parent is have good grandparents on hand. Mm-hmm. So thank you to my mom for hanging out with my kids who indicated they were interested in watching me today. So nice. I just wanted to give Isabel and Jack a shout out and say,
give them a wave.
Be good for Yaya.
Yeah. Very nice.
Yeah, Rob mentioned the two cases. One was a Beavers case, and the other one was a murder case. And you got maximum sentence for the Beavers case and guilty for the murder case. So am I right on that?
More or less, okay. Yes. The Beavers case, the judge kind of fashioned his own sentence that ended up with being pretty hefty. The murder case we tried last week, it's with murder cases in West Virginia, if it's first-degree murder, the jury chooses the sentence, and so in this case, they chose life without parole, so he'll never get out. But I am in kind of a weird spot as both the prosecutor and a judge-elect, where the judicial rules of ethics, the canons apply to me, even though I haven't taken office yet. So I can try these cases, but I can't send out press releases or make comments on them because they are, even though we have the conviction and in some cases the sentence, they're going to be appealed, and the court considers that still an active case that I can't comment on.
Do you remember your first case when you first took office after being newly elected?
That's a kind of a hard question to ask. First case that went to trial or first case that I appeared in, or, I don't...
Your call. Whatever one you felt like you were most involved in helping to direct the case to the appropriate verdict.
The first case that we dealt with when I took into office that I didn't try myself, but was a difficult case to deal with, was one where it was a murder, and back then our state lab was incredibly swamped, and it took forever to get results back on a number of things, including DNA testing. And we had... the transition was rough when I first took office. We had this case set for trial within, I think, 6 weeks of me getting into office. And there was DNA from under the victim's fingernails that was still at the state lab. And this case has gone through the appeal process and the habeas process, so I'm comfortable discussing this part. The lab said, there's just no way we can get results back to you before the trial. So, and it was sort of one of the first real team moments I felt like my office. We worked with law enforcement to get that DNA transferred to the Marshall University DNA lab. They tested it. It turned out to be incredibly valuable evidence in the trial, and it proceeded as set, went to trial, and they got a guilty verdict and life without verdict.
You mentioned the crime lab and the backups that used to be in place. Do those no longer exist?
They are doing much better. They are absolutely very responsive. The office has had a great working relationship with the lab to kind of help triage, what's set first, when we want to indict things, to get them to be responsive. So that certainly is not a scenario that we'd have to worry about now. It was a unique set of circumstances that kind of brought everything together to make it happen that way. And we were certainly appreciative of being able to work with them and also work with Marshall to get everything in front of the jury that needed to be there.
Catie, the trial that's not a trial, but the incident that's creating a lot of interest locally is Jody Soto, the delegate-elect. Right now, it's in front of the magistrates, and I don't want to get too far ahead of the curve. But if it does go to trial, would it go before a local judge, or would it go out of the district?
That's a great question, and it really depends on the judge that it would get assigned to. So, I'm like I said, I'm in a position where I can't really comment on the specifics of any particular case, but generally, felonies like that that would end up in front of a circuit judge, it's up to that judge whether they believe that there's a conflict and they'd need to step aside, and if they do, it first goes to other judges in the circuit. It will be, the circuits are changing. So in January, we'll be circuit 27 and we'll have 5 judges in the circuit. I would be conflicted out. I would have to recuse myself because I can't hear any criminal cases where the crime occurred or was investigated while I was prosecuting attorney. So, but there would be, 4 other judges who could potentially hear any crimes that have occurred up until December 31st. And if there were conflicts, then it would go through all of them. And then if they all recuse themselves, then it would go to a judge from outside the circuit.
Yeah, you've been involved in a lot of cases in the last 4 years. So
some pretty serious.
Some serious. Does that mean you'd recuse yourself from most of the cases going before the circuits? What cases that would go before the circuit has not gone through the prosecuting attorney?
So any criminal case that arose prior to January 1, 2025, I will not be able to hear in Berkeley County. That means when I start, my docket will primarily be juvenile cases and civil cases. Juvenile delinquency and status offense cases, I can take any that arise after January 1, and those get to circuit court much faster than many other cases. Abuse and neglect cases, there are opinions that because the prosecutor is actually representing DHHR as their client, or DOHS as their client, the elected prosecutor is not conflicted from those cases unless the elected prosecutor personally participated in that abuse and neglect case. I've not had the abuse and neglect docket, so I'm not conflicted out of any of those cases unless they have an accompanying criminal case that the office was involved in.
Going back to the really important things at hand, the ceremony of you being made official, I understand a judge is actually going to be pinning you?
So what we will do is all of the judges for the newly created 27th Circuit will take their oaths. They'll start with the most senior and then end with me. They will already be judges. They'll already be robed. Will be coming up, and actually after I take my oath, which will be administered by my dad, then my family will come up and help me put the robe on, and that will be that.
Mr. Gilstrap. There I am, Mr. Gilstrap.
How do cases land with a particular judge? Is it a rotation? I mean, somebody does a bad thing or somebody's suing somebody. How does it end up with judge 1, 2, 3, or 4?
So it used to be, I think, a pretty ordinary 1, 2, 3, 1, 2, 3 rotation before e-filing. Now with e-filing, cases are assigned randomly as well, but it's not in like a 1, 2, 3 order. It is actually random. So one judge could get 2 cases, and then another one will get 1 case, but it's supposed to at the end of the year all even out and have been randomly assigned. However, in jurisdictions like ours where we'll have 5 judges, it gets a little more complicated. So we have one judge who will split her time between Berkeley and Morgan County. So she only gets certain types of cases in Berkeley County. And I, of course, won't get criminal cases. So they account for that in my docket. So there'll be 2 judges in Berkeley County handling juvenile delinquency and status offenses, 2 judges handling abuse and neglect cases, the remainder of the judges handling various other, criminal, civil, all sorts of things.
And who's managing that?
The circuit clerk.
Okay. And as a prosecutor, when you were prosecuting a case, would you lobby for a certain judge? And if I'm a defense attorney, am I lobbying for certain judges given the nature of a case?
I think the most diplomatic way to answer that is that each judge approaches a case with the same law in front of them, but certainly we have come to understand their feelings on different types of offenses. But we do not have any control over who gets that case.
Are you able to answer a magistrate question?
Maybe.
Okay, let's try it. Let's say that you have been accused of threats against a person. Let's say terroristic threats.
Hypothetically.
Hypothetically. Terroristic threats 1, hypothetically. And you go before the magistrate for as bail is assigned, correct?
Yes, that is correct.
Are you looking at a sheet that says this accusation equates to this as to whether or not you can get bail and how much the bail amounts can be? Is that set in stone for magistrates, or is there some leeway there?
This is, if you've ever seen the movie Office Space, when they go
Yes.
meet with the Bobs, and he says, "Now this is a hypothetical."
This is a great movie, by the way. Anybody who's never seen that movie would love it.
So, taking the particular offense you're talking about completely off the table, magistrates, there is some guidance in the code for what magistrates are to consider when they set bond amounts, but it's not a hard and fast rule. There are certain offenses where they're presumptively supposed to be given a personal recognizance bond. Obviously, any sort of felony is excluded from that consideration, but there are factors that magistrates are to look at. Like I said, it's not set in stone, and that's how you end up with varying bond amounts between different magistrates in different areas in the state.
If I have been imprisoned for making threats against a person, let's say direct threats involving the loss of life, and I make bail and am released, is there any responsibility on the court or anybody else to notify those who have been threatened that this person has been released?
So, again, I'm just going to discuss generally any sort of crime that would involve violence or a threat against someone or any victim, regardless of whether there's violence involved. There is what's called VINE, I can't remember what it all stands for now, victim something notification. You can sign up for that, and it will notify you whenever that particular individual is released from a facility, moved to another facility, and that applies to any incarcerated individual. It could be someone who's incarcerated pretrial. It could be somebody who's incarcerated after receiving a sentence, and you want to keep track of where they get moved, because anyone who's been sentenced starts at the regional jail, and then they go to a classification center, and then they go to one of a number of correctional facilities across the state. So that is a resource for anyone who is wanting to keep track of where someone may be and if they are released.
Is there a reason why somebody would not go to the ERJ who was local and would be sent to another prison?
That's not uncommon. And it could happen for a number of reasons. Sometimes the prosecutor's office works with the jails to put somebody somewhere else. Sometimes the court puts somebody somewhere else. Sometimes the jail does that of their own accord, and it could be for a number of reasons. So it's not necessarily uncommon.
In this hypothetical case, do we know why he was assigned to another jail?
And so that kind of makes it not a hypothetical anymore, Bill.
You're kind of dipping in and out of the play game we're doing here, Bill.
I really can't comment on that.
Katie, during your course of time in office, you've had some challenging cases and situations that have come up, not the least of which was a situation with the local sheriff's office. Talk to us about what it's like walking that line with another independently elected official who may have allegedly come up against a legal violation, and how your office has to politically handle that and legally handle it.
I think any elected position, there's a level of politicization that is difficult to navigate, because you always have to look at, what is the right thing to do. And serving as prosecutor has been absolutely the honor of a lifetime, and also a challenge in any of these situations, because I am, answerable to the people. I have to answer to that they elected me and I'm here to serve a job, but I'm also answerable to the law and to ensure that the law is being upheld in an equitable way. So it has been a challenge in many scenarios to make sure that I'm walking that line of doing what's right for the people of Berkeley County. But again, it's truly been an honor.
Yeah. No hypothetical, no individuals, just a question as far as procedures. Recently, a magistrate was involved in signing the protective order. Another magistrate was involved in setting bail. A third magistrate will be involved in reviewing. Is this common? Is this common that you'd have multiple magistrates or multiple? I don't think you'd have it on the circuit level, but magistrates involved in a given
Yes,
case? Okay.
pretty much any case that goes through magistrate court is likely to have more than one magistrate involved, because most of the time when a case originates in magistrate court, it either originates by an officer arresting someone or filing a complaint for that person's arrest. And then that will, if it's a complaint that's signed off by a magistrate and it's whoever's on duty and doing walk-ins at that time. If it's an arrest, the arraignment is whoever is doing walk-ins at that time. But then that case gets assigned to another magistrate down the road who then hears that case. And that dovetails perfectly into one of the things I wanted to talk about, which is space. We badly need space. I think that is something that could help scheduling with magistrates, because we have 6 magistrates. We're about to have a 7th magistrate, and we have 2 courtrooms. So the way they divvy up duties, I think they're certainly doing the best that they can with the space that they have, but could maybe be more streamlined if we didn't have to fight over courtroom space.
I think it's 2027 that's going to be addressed. The Crawford building is going to be reconstructed to be modified to for more court space.
I certainly hope so.
I believe it's 27. So
I have kind of a research question, maybe a self-serving, but if the police make an arrest and I don't know, it's drugs, pick whatever you want, where is the decision made? There's been a local crime committed or a state crime committed, but then maybe it's a federal crime. Where's the decision made whether it's prosecuted as a federal or local?
That's a good question, and it's a little of both. It really depends on the crime. Only certain crimes can be prosecuted federally.
Right. Well, it has to be. Yeah.
Right. So
is that a negotiation between the prosecutor and the
U.S.
Attorney's office?
Sometimes.
Like who wants it?
Sometimes. Sometimes it's a consideration of what sentencing is available, what programs are available here versus there. What they're willing to take. They have sort of the luxury of reviewing cases and saying that yes, they do want this, or no, they don't want this, and the state gets what's provided to us and needs to move forward to make sure that they're serving the community. So it really depends on a number of factors. Again, there are some crimes that are federal crimes and not state crimes, and obviously there are a number of state crimes that are not federal crimes. But generally speaking, the vast majority of cases originate at the state level, and then there's potential for it to be further investigated and prosecuted federally. And I think in a lot of cases, civil cases are the same, where they might originate in state court and be removed to federal jurisdiction.
1 minute left. Catie, you get sworn in Wednesday?
Tuesday.
Oh, tomorrow. That's right.
Yes.
Tomorrow. Yeah, what time?
4 p.m.
So what do you think?
I'm excited. Like I said, it's been the honor of a lifetime serving the people of Berkeley County as their prosecuting attorney. I have loved, I don't want to say every minute, but most minutes of it, because it can be a very, very stressful job. And it's been amazing. And I'm very much looking forward to continuing to serve our community, to serve both Berkeley and Morgan counties in a little bit of a different role. I think that this is going to be a great change for my family. I think this is going to be something that is suited to how I want to approach my life and give back to the community. So I'm grateful for the opportunity.
Congratulations on a job well done.
Thank you.
And let's hope I never have to see you at work. By the way.
Same.
Back with the final minute after this.